Calvin Riley is innocent. You have every reason to question every single thing these officers testified about. They are not credible. Officer Oliver lied to you under oath, and she lied over and over from the second she pulled Mr. Riley
Objection,
over.
inflammatory, and misstatement of the law.
Over and over from the second she pulled Mr. Riley over until the second she got off that witness stand. Officer Muth lied to you about what she placed Mr. Riley under arrest for, and she lied to her sergeant about what she found in the car. These officers are making things up. These officers are laughing. These officers are asking each other if their cameras are on. These officers are turning off their cameras. These officers are taking an oath to swear to tell the truth, and then these officers are lying. They did it right there in front of you. When you apply the law Judge Jones instructs you on, with the conflicts in the evidence and the complete lack of evidence you have seen over these 2 days, it is clear Calvin Riley is not guilty. Officer Oliver opened a bottle of vodka, a bottle that had never been opened before. You hear her break the seal, pour it out, and then put it back in the car. Then she used that evidence against him. She and Officer Muth told their sergeant they found a bunch of alcohol stashed in his car, and that the bottle was open. This is simply not true. There is nothing in that cup, which, if you watch the video closely, has a lid on it, and the vodka bottle that was opened by Oliver. Members of the jury, these officers want you to believe that they only turned off their cameras because they weren't investigating anymore. Yes, they were. The sergeant on scene asks if they're live. Officer Muth asks if they're live. Oliver shakes her head no. Sergeant turns his off, and Muth turns hers off. They are all still investigating. Your jury instructions tell you that you all get to decide what is reliable. Nothing that these officers testify to is reliable. Let's start from the very beginning. Oliver and Muth are at a completely different traffic stop. Oliver says she notices Mr. Riley's car going by without headlights and at a high rate of speed. She doesn't have a radar gun. That's just her word, which we know is not believable. She tells you that he was swerving. None of that is captured on her camera. There is no camera footage of it. It's just her word, which we knew is not believable. She tells you that she noticed his eyes were glossy through his glasses. And on Friday, for the first time, she adds that they're bloodshot. She's been under oath twice before, as well as written a statement that was also under oath. And none of those 3 times did she ever say they were bloodshot. The first time was on Friday. Members of the jury, you can see Mr. Riley's eyes on camera. At one point, he leans into Officer Muth's body camera. His eyes are not glossy. His eyes are not bloodshot. Again, her word is not believable. She tells you that she smelled an odor of alcohol. But in her camera footage, the first thing she tells Officer Muth is that she can't really smell anything. She tells you that she smelled marijuana. Again, after telling Muth that she can't really smell anything. And there is no marijuana, paraphernalia, or anything regarding it, nothing found in the car. And let me take a moment to point to something out here, because the state is making a huge deal about Mr. Riley yelling. The officers call him belligerent and irate. Members of the jury, he's completely cooperative and polite up until she says she smells marijuana. That's when it all changes. At that point, he knows exactly what they're trying to do. And yet, he is absolutely upset. And he was very right to be. He was falsely accused for something, and he is mad about it. He's completely justified in acting the way he did. And also remember how he interacts with Muth at first, cooperative with turning off the car, cooperative with taking the keys out, cooperative with getting out of the car. Remember how he interacts with Sergeant Smith. Completely cooperative and respectful. It is only when Officer Oliver says that she smells marijuana, either saying she couldn't smell anything, that he gets upset. And it is completely understandable. So now Muth gets on scene. Oliver asks her to verify Mr. Riley's address as 429 West Brevard Street. But when asked, Mr. Riley said it was a family house. He never said that that was his residence. That was something that Officer Muth just assumed. And remember, at this point, it's 2 officers there with Mr. Riley. Oliver wants Muth to see if she thinks this is a DUI and is excited to watch her conduct an investigation. Officer Oliver promises that she'll do the next one. The state wants you to believe that the evidence tampering and the lying about it doesn't matter because he was already under arrest for DUI. But that is not true. When they order him out of the car, which he does cooperatively, they arrest him, handcuff him, and tell him it's because his license is suspended. And again, when they're searching his car, they indicate that they're going to charge him with driving while license suspended. They say DWLSR, which means driving while license suspended or revoked. They are telling him that he was only under arrest for a suspended driver's license. But now they want you to believe that he was under arrest for DUI. Their testimony was that he should have inferred that he was under arrest for DUI. But members of the jury, the law does not allow you to make inferences. That is reasonable doubt. The very first time that anyone tells him that he is under arrest for DUI is when they're taking him to jail. That is the first time they tell him that. And that is after they've already searched his car and used that bottle of alcohol as evidence against him. And this is also very important distinction, members of the jury. Remember, at this point, all the police need is probable cause to arrest someone. That is a very low standard versus what you must today, here in the trial. When a man's liberty is at stake, the law is clear. The state must convince you of every element beyond and to the exclusion of every single reasonable doubt. And there is overwhelming doubt in this case. Now, Mr. Riley is in the back of the police car. He is under arrest. And again, at this point, he is justifiably and understandably upset. But members of the jury, listen to him. Listen to his speech and his articulation and his communication with the officers. He is not slurred. He is not confused. He is just mad that he is being falsely accused. And now we get to the search. And I would encourage you to watch the search from both of the officers' angles, both Officer Muth and Officer Oliver, who both had body-worn cameras on. The first thing they notice is an air freshener. Or maybe it's cologne, they think. But according to them, it is very strong. And they immediately assume he must have sprayed it right before they came up to his window. But they absolutely have no evidence of it. Then Oliver finds the bottle of vodka, and Muth immediately assumes that's what's in the cup. Members of the jury, this is a never been opened, completely sealed, closed bottle of vodka. But it doesn't matter, because Muth just knows, based on her training and experience, that it must have been what was in the empty cup. That empty cup that she later tells Sergeant Smith has a mixed drink in it. Again, with no evidence of either of those things. She's assuming things, again, and the law does not allow you to assume. The jury instructions do not allow you to assume. And here, please pay close attention to what they say and how they say it. They are laughing. They are laughing, members of the jury, and they are using those magic words that as officers they use. It's based on my training and experience. And it's because they know that with those words, they can do whatever they want. Think about this too. Let's talk about the smell. You have so many inconsistent statements about the smell, which is a factor that Judge Jones tells you should consider in weighing credibility. At first, Oliver can't smell anything at all. Then Muth says there's an odor of alcohol. Then, when they get him out of the car, Oliver says she smells marijuana, which Muth testified that she didn't smell at all. But also, Oliver says he reeks of alcohol. Then, when they go back to search the car, using the smell of marijuana to do that, again, which Muth did not smell, they immediately smell air freshener. Then say, oh, it must be cologne, and it's a very strong odor of cologne. So which one is it? You have to have questions about all of that, and that is a reasonable doubt. And I know it was frustrating. I'm sorry that we had to get up and down and in and out during the testimonies. But it's because every time the officers were confronted with their own inconsistencies, they wanted to fight it. Remember the jury instruction. Was the witness honest and straightforward in answering the attorney's questions? No, they weren't. Remember Muth's words to you. According to her, when people give inconsistent statements, it means they're impaired. Under that logic, every time that these officers had given inconsistent statements, under oath, they must be impaired. Now, bottle of vodka. Please do not believe that this is a simple mistake. Do not believe that this is not a big deal. It is not just that Oliver did what she did, but it's that she lied about it under oath in a pretrial hearing. The bottle had never been opened before. You hear the seal break when she twists it off and throws it back in the car. On scene, all the officers continuously refer to it as open. Sergeant Smith specifically asks if the bottle was opened. Muth says yes. And he shrugs in agreement because they all know an open bottle is a huge piece of evidence for DUI investigation. And also remember, they're all asking if they're live, if their cameras are on. And right after that, they all turn them off. And today, again, Muth wanted to deny that she used the bottle of vodka as evidence, even though, again, under oath at a pretrial hearing, she said that she did use it as evidence. Members of the jury, it is not against the law to drink and drive. What the state has to prove to you beyond and to the exclusion of every single reasonable doubt is that Mr. Riley was under the influence of alcohol to the extent that his normal faculties were impaired. They weren't. They just weren't. He thought his headlights came on automatically, which is reasonable. There is no evidence of his speeding. His eyes are not bloodshot or watery. That's all the evidence that they brought you. And because there wasn't any other evidence, the police manufactured their own. On page 2 of your jury instructions, you'll see the definition for normal faculties. Sergeant Smith today testified that Mr. Riley was able to walk from one car to another, that he didn't trip, stumble, or fall. He testified that Mr. Riley was able to make a call, dialing the number, even with his hands handcuffed behind his back. Gratefully, thankfully, there was body-worn camera footage that night because without it, everything Mr. Riley was worried about would be true. That these 3 officers would make up a story and evidence against
Objection
him.
declaratory.
Overruled.
That these 3 officers would make up a story and evidence against him, and it would just be his word against theirs. But thankfully, there was footage. At least there was footage some of the time, as their cameras were off some of it too. What else did we get to see in that footage? We got to see Mr. Riley, a 56-year-old man, born and raised in Tallahassee, Florida, a barber who had employees that worked with him at his shop, a man who had to endure this awful, horrible night with 3 police officers surrounding his car, arresting him, and making up evidence against him. Judge Jones read you the instruction to reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find Mr. Riley not guilty, because the doubt is reasonable. If you have questions, those are doubts. If you think Mr. Riley didn't look impaired, that's a reasonable doubt. If you question whether just 2 beers makes someone impaired, that is a reasonable doubt. If you question all the different smells and odors that these officers claim to have smelled, that is a reasonable doubt. If you question Officer Oliver's actions, which you absolutely should, that's a reasonable doubt. If you question Officer Muth's actions, which you absolutely should, that is a reasonable doubt. When you use Judge Jones' instructions and questions whether these witnesses have given testimony today that is different with previous testimony, which they have, that is a reasonable doubt. When you know for certain that they only told Mr. Riley he was under arrest for driving on a suspended license, and it wasn't until after they searched his car and planted evidence that they then charged him with DUI, that is a reasonable doubt. Now, members of the jury, I'm about to end my argument, and the state is going to come up here and have the last word. These officers get to arrest Mr. Riley, lie about the evidence they found, and then the state gets to have the last word in trying to convince you to disregard all of that. Please don't do that. Remember all of these reasonable doubts, but most important, use your common sense. Use your own review of these officers and this footage. See the truth. Understand why Mr. Riley was so upset. Because he was being falsely accused, falsely arrested, and evidence was falsely manufactured here. They have the last word up here, but you get to have the last word back there. This case is full of reasonable doubt, and when you follow the law in this case, your last words have to be not guilty. Please find Mr. Riley not guilty.